Welcome this morning to Managing Your IP Strategy using a trading subsidiary with myself, Steph Caird, and James Field. So the agenda of what we're hoping to cover today is the common types of IP that is exploited through using trading subsidiaries, the benefits of using a trading subsidiary to exploit your IP, the different options of exploitation, other things that you might want to consider when you are using a trading subsidiary to exploit your IP, and a bit about knowing your IP assets. And then hopefully at the end, we'll have a bit of time spare to go through some Q&A. So as I say, any questions that pop up while we're going through this, please just add them to the question box and we'll get to them at the end. And without further ado, I will hand you over to James. Thank you very much.
Thanks, Steph. Hi, everybody, and thank you for joining us today. So, as Steph's outlined, I'm going to talk you through some of the key considerations for universities that are managing their IP through a trading subsidiary. Before getting into the detail of the actual exploitation, we did think it would be useful to have a quick recap as to common types of IP that the subsidiary might be exploiting. So probably the most obvious type of IP from an exploitation perspective is a patentable invention. So a patentable invention is basically a product or a process that satisfies various criteria. And the key criteria include one, that it's new in comparison to the state of the art of everything that's gone in that field beforehand at the time of the application. Two, that it involves an inventive step. So basically, whatever the kind of technical learning that comes from the invention represents a genuine step forward to what's gone in the field before. Three, that it's capable of industrial application. And four, that it isn't specifically excluded from protection as a patent. If it satisfies those criteria, then a patent application can be made, and if a patent is granted, then it gives the holder a limited monopoly over the invention for as long as the patent is in force. Initially, that's 5 years. It could, provided maintenance fees and so on are all paid on time, that can continue for up to 20 years of certain medical patents, potentially slightly longer. Another common type of IP that you might want to exploit is copyright. So broadly, copyright protects various types of work which are the original expression of the author's ideas. It is worth emphasizing there it's the author's expression rather than the ideas themselves. And regular examples of that in a university context might be written reports or papers that detail research findings or know-how, potentially source code in computer programs, and it also extends to certain artistic, musical, dramatic works, sound recordings, films, things like that. Unlike patents, copyright exists immediately. There's no need to register, and it will last for 70 years following the death of the original creator of the work. I'm not going to go into too much detail about designs and trademarks, but it is possible that the university could have registered designs, it could have unregistered designs, it could have a combination of both that it's seeking to exploit. And equally, trademarks could be involved as well, although it's probably fair to say with trademarks that it's likely to be ancillary to the exploitation. It's very unlikely that you would be setting up a trading subsidiary just to exploit a trademark. Finally, a quick word on what we've grouped together as quasi-IP considerations. So as the name suggests, these aren't directly IP, but in many cases, they'll be almost as valuable as the IP rights that are going to be exploited. It could be things like know-how, confidential information, raw research data. It could also be, particularly in the life sciences context, starting materials, things like cell lines that are actually needed to kind of work up to, for example, the invention that is protected by the patent. And these are really important to think about as well, because for example, if you've got a right to be able to use patents at the trading subsidiary, that might not necessarily be enough to fully exploit it if there isn't also the knowledge that goes alongside that's needed to be able to work with these with these materials, and if you've got the starting material or if you haven't got the starting materials themselves as well. So Moving on to look at what the benefits of the university exploiting the IP through a trading subsidiary might be. This really will depend on what it is that the university is trying to achieve through the exploitation. But as a first port of call, it's always worth thinking about the university's charitable objects. So presumably that's already a part of your decision-making processes. But do just bear in mind that university-owned IP will be a charitable asset, and so it needs to be applied in a way that is compatible with the university's charitable objects. And with that in mind, there can be greater freedom to pursue the exploitation through a trading subsidiary, which isn't directly subject to the same charitable objects. There'll still be an obligation on the university to ensure that it will achieve fair value in relation to its contribution to the IP, and that could be measured, financially. It could be potentially think about like public rights to be able to publish research results. It could be thinking more generally about the public benefit as well. But it is clear that the trading subsidiary can be set up in a way that it can engage in certain non-charitable trading activities in a way that the university can't necessarily directly do itself. Equally, if the trading subsidiary does engage in those trading activities, and then later down the line it gets into some kind of financial difficulties or there's some kind of liability that arises, there is a degree of separation between the trading subsidiary and the university because they're separate legal entities. So that can give a level of protection to the university potentially and its other charitable assets. Another key point, which is especially important in the context of IP, is that the trading subsidiary itself can be a useful vehicle to channel particular expertise, personnel, resources towards the trading activities. So I touched on this earlier with the quasi-IP considerations, but if you think about, say, for example, patent rights, just having the right to be able to use the invention it might not be enough to sort of cover everything in practice and successfully be able to exploit. If you haven't, for example, got access to various know-how that goes alongside it, and but by its nature, confidential know-how can quite often just be kind of in the heads of people at the university, and so it's not uncommon to see university staff, particularly the inventor in the context of patents, working together with the trading subsidiary, maybe on a consultancy basis. And because the trading subsidiary is able to focus more clearly on the trading activities themselves, that knowledge can then be more clearly directed, channeled towards pushing forward those activities as well. So looking to what else the university should be thinking about when setting up the trading subsidiary, one of the core considerations from an IP perspective is how exactly does the university want to exploit the IP? So this can be done in two ways. Either the university can assign the ownership of the IP over to the trading subsidiary, or it can hold on to the ownership of the IP and it can grant a license to the trading subsidiary that will allow it to go on and exploit. And there's various benefits and drawbacks with both of these options. So taking assignment first, an initial benefit to the university is that it might be able to quite quickly realize some income from the IP. So in a standard assignment agreement, the transfer of ownership will happen immediately or very soon after signature. And the purchase price will normally be passed in the other direction at the same time or very shortly thereafter. So it's quite clear that if one of your key drivers is that you need to get some kind of income arising from this IP quite quickly, assignment can be a good way of doing that. Having said that, it is worth thinking that if the trading subsidiary has been set up specifically to exploit this particular type of IP, or this particular piece of IP rather, there might be a question as to actually what does the trading subsidiary actually have in the way of funding, and the university needs to obviously think that through, because it needs to be clear that it's achieving fair value in return for its charitable assets. Another potential benefit to the university is that the transfer of ownership of the IP represents a very clear break in who is responsible for it. So, for example, if there's some liability or challenge relating to the IP that arises, or maybe there's some kind of prosecution or maintenance cost that comes out, um, provided that whatever it is doesn't relate to something that happened while the university owned the IP, um, because the university and the training subsidiary are two separate entities, it should be the trading subsidiary's responsibility as a first port of call, and that gives a certain amount of protection and kind of separation for the university and its other assets. The flip side of this is that by assigning the IP, the university is likely to have less control over the manner in which the IP can be exploited once it's been assigned. So, as we've already discussed, the university and the trading subsidiary are two separate entities. Once the assignment has happened, the IP in question is owned by that separate entity, the trading subsidiary. Um, and so it is possible to build into an assignment agreement various considerations around ongoing monitoring, around reporting that might need to come back to the university. That can potentially look a little bit odd in the context of something where the university doesn't actually own the IP anymore. And it's worth just not to say that it can't be done, but it's worth just bearing in mind that that's something that could be questioned potentially by possible investors later down the line if they're looking to come on board into the trading subsidiary as well. Uh, Looking at licensing. So one of the key benefits for the licensing of IP for a university is that it's likely to be able to achieve income from the exploitation of the IP over a longer period of time. And that will normally be done through some form of royalty arrangement that is set up from the trading subsidiaries' exploitation activities. That can also be combined with various milestone payments, for example, that are going to be built in over the course of the license. And it's worth thinking on that. If one of the university's drivers is it does need to receive some income quite quickly, there's nothing to stop setting up a milestone that's is achieved essentially on execution of the agreement or is achieved very early on within the process. So there are potential flexibilities there. Equally, if the university does want to exercise greater control over the subsidiaries' exploitation of the IP, it wouldn't be unusual in a licensing context to include reporting and monitoring obligations, and also to generally just have provisions that are geared towards incentivizing the subsidiary to exploit the IP on the widest possible basis. A drawback of that for the university is that obviously you will need to sink time and expense into actually engaging in that monitoring process. But if the income is going to be received over a longer period, then it might be a worthwhile exercise, a worthwhile expense to take on board. Another option, which is more readily available to the university in the licensing model, is to grant a right to be able to exploit the IP to the subsidiary in a defined field. And by this, what the university is doing is, but by holding on to the ownership of the IP, it's allowing the subsidiary to exploit the IP in a particular field. But at the same time, it's also retaining the right to be able to exploit the same IP in other fields. And it might be able to do that directly. It might be able to do that, for example, with licensing with other parties, and that those other parties might be parties that have greater expertise in the other whatever the other field is that you're looking to exploit in as well. On the other hand, as well as the potential higher costs arising from monitoring, another potential drawback around licensing can be if you think that if the university is going to continue working with the licensed IP itself, even if that's only in an academic capacity, and that goes on to lead to the development of improvements to the IP. It's not unusual to see licensees that try to essentially reach through and be able to automatically get a right to be able to use those improvements in the exploitation of their IP as well. Um, that that is potentially tricky for the university. First of all, because obviously at the point when the license is executed, you don't necessarily know what those improvements might be. Also, you need to be thinking about, again, the need to achieve fair value in relation to the assets, and that would apply to the improvements as well. And so we would always recommend making sure that any improvement provisions in a license are carefully drafted to ensure that there isn't kind of a clear, like, automatic stream of improvements without any kind of limitations. Um, Certain restrictions that might be built in here are things like a reference to a time period. So it's only improvements that are developed during a particular time period following signature of the license that will be provided. Or it could also be, for example, limited to work that's done by a particular academic and their team, maybe. So various considerations there. As you can see, there are various benefits and drawbacks to both licensing and assignment models. It's also worth saying it's possible to combine the two. So we've seen deals where there's an initial out license, but where the trading subsidiary achieves a certain milestone, there will then be an automatic assignment of the IP from the university to the subsidiary. Equally, a slightly more watered down version of that might be that when the milestone's achieved by the subsidiary, it gets an option to require that the university makes the assignment. Whatever type of agreement the university chooses to enter into with the subsidiary, there are other things that need to be considered as well. So the first of these are flow down obligations. And basically here, what we mean is, are there any obligations on the university in relation to the IP that need to be flowed down to ensure that the trading subsidiary complies with them as well? The risk being that if the subsidiary doesn't comply with them, is it going to put the university in breach of those obligations to whoever the third party is that they owe them to? And this is quite common to see, for example, in research funding. So where a third party funder provides funding for the research, and they might impose various obligations on the university. The IP is then created through that research, and that's where the flow down obligation kicks in. So it's always worth bearing that in mind. Another point, which is specific to patents, but should really be thought about, is so when the university is speaking with the subsidiary, or the subsidiary is going to be speaking with third parties, if at that moment there hasn't been a patent application in relation to the invention hasn't been filed with a patent office, you really need to make sure that everybody is going to be acting under appropriate obligations of confidentiality. The risk there is, so earlier I mentioned that one of the criteria for patentability is novelty. If there is a novelty destroying disclosure, that could seriously affect the ability to be able to get a patent. And if a patent isn't available, then it might then become quite unclear how exactly the IP itself is going to be, or rather the invention itself is going to be exploited at all. Uh, Also, it's worth thinking about other requirements that the university might have. So it will likely have ethical trading requirements, and there'll also be various procedures that need to be followed to ensure that the university's reputation is protected as well. And you should really think about how the trading subsidiaries' activities might interfere with whatever those requirements are. And on a related note, it's also worth thinking about where the university's requirements might be best dealt with. And by that, I mean, what document might it be best to set them out in? So looking at the slide, the flow down obligations and the confidentiality, that's quite specific to the particular type of IP that's going to be exploited. It would be quite normal to deal with that in the exploitation document, so in the assignment or in the license. The ethical trading and reputational protections are maybe more slightly across the board, as in it's generally how the trading subsidiary should be operated. And in those circumstances, it could be dealt with in the exploitation documents, but it's also worth thinking about whether there's somewhere else that it could be set out. So, for example, If the university's got various parent control provisions through the trading subsidiaries corporate documents, is there a way potentially of just setting these out in a policy and saying requiring that the subsidiary will comply with the policy? Is there going to be an intergroup service level agreement? Is it best set out in there? It's always worth bearing these things in mind. So moving on, we would also always recommend that any university that's looking to exploit the IP through a trading subsidiary will ensure that it's carried out as a proper internal due diligence process on the IP assets. And this is really important. So key things that we quite often see, I mentioned earlier, the flow down obligations. That's a very common thing to see that obviously you need to ensure that you're covering off in the exploitation documents. Other things to think about, are there any ongoing projects using the IP? And do they then need to be carved out of any license that you're granting? Or if there's an assignment, do you need a license back to enable whatever that ongoing project is to actually carry on going? Another thing to think about is whether the IP is jointly owned or is it already licensed to a third party in a way that has some kind of impact on the scope of the license or the scope of the assignment. And another really key point is the use of the IP dependent on access to any background IP or pre-existing IP that belongs to the university or a third party? If that is the case, what is that background IP, and how can it be shared with the trading subsidiary? And that's really important, just thinking about just making sure that we've got that everything will end up with the trading subsidiary to allow it to actually be able to exploit it successfully. Once that DD process is complete, we should then think about does that have any kind of effect on the warranties that you might be given in the IP exploitation documents? Again, for example, if there's an ongoing collaboration using the IP, can certain warranties about how it's being used or whether it's being used in other contexts be provided? How do those need to be caveated in some way? And it's also always worth considering whether the university will require a reservation of rights or some kind of license back in relation to the IP that's going to be exploited by the subsidiary. So quite commonly, we'll see universities reserving a right to continue using the IP for academic or teaching purposes. There might be pushback on that sometimes, particularly in a spin-out context, around, for example, whether or not the university has a reservation to use those rights in a particular field. But again, it's always worth taking those into consideration before going into any kind of negotiation of the exploitation documents. So that was a very quick whistle-stop tour of exploiting IP through trading subsidiaries. We've just boiled these down into a few questions for you to bear in mind. So number one, what is the IP? That's both what kind of IP is it? Is it a patent? Is it copyright? And also, is it what DD has been carried out specifically on that IP? Are there any conditions that are attached specifically to that IP? Secondly, what do you want to do with the IP? And that will probably guide as to whether or not the trading subsidiary is the best way to go about exploiting it. Assuming that is the case, is an assignment or a license the best form of exploitation? And we've discussed the various pros and cons of that. Fourthly, are there any other university requirements that need to be fulfilled, and how might they be, like where might those be set out? And finally, is there anything arising from the due diligence on the specific IP assets that will need to be included in whatever the arrangement is going to be with the trading subsidiary? Okay, so thank you for listening on that, and we'll now move on to some questions.
Thanks, James. I think it's worth also noting that some of the things that James has mentioned will be relevant in the spin-out context as well. So not just a wholly owned subsidiary where you might be using them as a vehicle to look after your assets, or you're setting something up that might potentially in the future become investment ready and then spin out. particularly where you have grant funding terms, for example, contractually you might be obliged to flow those through to your trading subsidiary, even if you don't have any intention of spinning things out. I don't think we have, we've just had some questions in the Q&A sessions. So one of the first question we've got is, have we got comments about agreements requiring an assignment back to the university where milestones aren't reached? So my thought on that question is that assignments back where milestones aren't reached, if you're talking about a wholly owned trading subsidiary where it's more of an intra-group arrangement, and you're not intending for them to be invested into by third parties, probably less of an issue. If you are setting something up with the intention that third parties are going to be involved in investing in that company, they are likely going to query those kind of assignment back triggers, because that then risks them having put money into a company on the basis of IP rights that then revert back to the university if they haven't met a milestone. But you can manage things like that through being actively engaged with the development plans with that relevant subsidiary. So that would be my thought on that. It can be challenging, but not not impossible to do in a way that can keep people on side. The other question that we had was if the university has a wholly owned trading subsidiary, is the fair value issue still an issue, or is it a future issue should the ownership in the subsidiary change?
Yeah, sorry, I seem to be having a technical difficulty there. Yeah, so I'd say with the fair value issue, it's something that the university needs to be considering like at all times. So where it's a trading, sorry, where it's a charitable asset, that is something that needs to be applied in accordance with the charitable objects of the university. So even if it is a trading subsidiary that is going to be wholly owned, the university still needs to be sure that it is achieving fair value for it, and that it is basically complying with its obligations under charity law.
Thanks, James. There was another question separately that James and I had been thinking about in the context of increasing use of AI in research, particularly academic and scientific research. Do we think that the licensing and assignment position changes if the IP was created using IP?
So I think, yeah, if the IP has been created with the involvement of AI, I'd definitely say that that's very much something that should be considered at the due diligence stage. I mentioned earlier about so with copyright and patents, for example, there's the originality, there's the novelty requirements. In the context of where an AI tool is being used, we really need to think about, okay, well, what was their original thought? But was there an original creation that's come from university staff, and that will really go to then who actually owns the IP there. As a general rule of thumb, it would be worth looking at whatever prompts were put into the AI tool to generate whatever the output is, and the more specific that those prompts might be, the more helpful that generally could be to the university around ownership. However, there are various other things that need to be borne in mind. There's are there any end user requirements around the use of the AI tool? Also bear in mind that AI tools can draw from third-party material. So is there a potential risk of some kind of infringement of third-party IP rights? That also needs to be borne in mind. However, if all of those things have been taken into account, then kind of having as clear an idea as to how that is going to be, like what the background is, what conditions might be relevant, what specific considerations might need to be taken into account, how that can then be flowed into the exploitation documents. It kind of then once provided the DD process has been completed around that, then it's something that can be dealt with at the exploitation stage quite clearly.
Great. Thanks very much, James. So received, and we have got one more session in this series coming up, which is on the 6th of November. And that is all about how to successfully exit. So once you've set up your trading subsidiary, you have got management of IP all sorted out, but you then want to stop using a trading subsidiary. Neil and David will take you through that on the 6th of November.